Assalamu alaikum and welcome back to our deep dive.
It's great to be here.
Today we're digging into a really fascinating set of ideas, and our sources come from the book True Courtroom Stories, which was researched by Mr. Zahir Ahmad Mir.
That's right.
We're focusing on a theme from what's noted as Episode 113, Environmental Justice. And honestly, it raises what might be one of the most important legal questions of our time.
I think so. I
Yeah.
mean, we so often talk about environmental issues in terms of policy, right?
Sure, regulations, treaties, carbon taxes, that kind of thing.
Exactly. But what happens when protecting the planet moves beyond just, statutes and legislation and gets anchored directly into the concept of fundamental human rights?
That's a huge shift.
It is. And that's really our mission for this deep dive, to unpack how courts all over the world have started to expand the legal guarantee of the right to life to include something new, the absolute necessity of a healthy, clean environment.
Okay, so let's lay out the roadmap for everyone listening. Our sources give us four really clear, interconnected pillars that show this global shift. I kind of think of it as building a legal skyscraper.
That's a perfect analogy. You have to start with the foundation and work your way up. It's about showing a continuity in legal thought.
Right, so we're going to start with that ancient bedrock, a model of stewardship that's actually rooted in Islamic tradition. It's a concept called Hisbah.
The original legal backbone for environmental accountability in many ways.
Then we move into the modern era with the steel frame of our skyscraper, a movement called environmental constitutionalism.
That's what gives environmental protection the highest possible legal standing. It puts it at the top of the pyramid.
From there, we'll look at the blueprints, a specific, really influential court case from Pakistan, the Shehla Zia case.
Which is a fantastic, practical example of how judges can interpret old rights to meet very new, very modern challenges.
And finally, all three of those pillars come together to support the penthouse, I guess. The final legal conclusion, the ratio decidendi.
The binding legal principle that ties it all together. The powerful idea that the right to life includes a healthy environment.
And for you listening, understanding these 4 points isn't just academic. This is the blueprint. This is the legal ammunition that citizens and activists are using right now to challenge pollution. You're not just arguing about a small fine anymore.
No. You're arguing about a constitutional violation, an attack on the basic ability of people to exist with dignity. It's law catching up to the existential threat of ecological crisis.
So let's start at that bedrock, long before the first modern environmental agency ever existed.
Let's do it.
Okay, so we're going back in time now, into history, into jurisprudence. The source material points to the protection of water and land within an Islamic framework, and it's all anchored by this concept of Hisbah. Before modern laws, how did societies codify a duty to protect the environment?
Well, what's so fascinating here is that this idea of environmental stewardship, it's not some new secular invention from the 1970s.
Right, it wasn't just invented on the first Earth Day.
Not at all. It has these deep, formalized legal roots that show a historical link between, public morality, public accountability, and the health of the ecosystem. Hisbah is the legal mechanism that codified that link, hundreds of years before European common law even started to regulate things like public nuisances.
So what exactly is Hisbah? Because I think for a lot of our listeners, they might hear that and think of it narrowly, maybe as just religious policing, but the sources suggest it's much broader.
That's absolutely the key nuance to get. While the word Hisbah does relate to accountability, enjoining what is right and forbidding what is wrong, it was institutionalized. It wasn't just a vague idea. It was an actual office, the office of the Mutasib.
The Mutasib.
Yes. And you can think of the Mutasib as a kind of public ombudsman, a market inspector, and a city administrator all rolled into one. Their job was to enforce social, moral, and economic standards, but specifically where they impacted public rights and the common good.
Okay, so if their main job is protecting the common good, how does that moral or economic duty translate into something like environmental protection? How do you get from market regulation to protection of water and land?
Because public health and public welfare are completely inseparable from environmental health. You can't have one without the other. If your mandate is to protect the common good, you are by default mandated to protect the common resources that good depends on.
The air, the water.
Exactly. The core concept here is public property and public trust. Resources like a river, the air, a public path, these are considered common rights. So polluting them isn't a private matter, it's a public injury.
And the mutasib was the one with the authority to step in.
Yes, and they had sweeping authority over things that look a lot like modern environmental regulations.
Can you give us some specific examples? I want to understand what this looked like in practice.
Absolutely. Let's start with the most critical one, water quality and access. This was probably the mutasib's most important environmental duty. They were tasked with policing all the communal water sources.
So rivers, canals, the public fountains, wells?
All of it. They had to prevent contamination. For instance, let's say you have a craftsman, maybe a dyer, using chemical pigments, or a tanner processing animal hides.
Both pretty noxious industries.
Very. And they're dumping their wastewater into the stream that the town uses for drinking water or for washing or for irrigating crops. The mutasib had immediate actionable authority. They didn't have to wait for a new law to be passed. They could intervene right then and there.
That sounds like the earliest form of administrative pollution control. So what could they do? What kind of punishment are we talking about?
Well, the intervention was serious. This wasn't just a slap on the wrist. First, they could order the activity to stop immediately, just shut it down.
Wow.
Then they could compel the polluter to clean up the mess. They could enforce heavy fines. And, critically, they had the power to force them to relocate their entire business outside the community, away from the water source.
So it was a real enforcement mechanism.
A powerful one. Because the harm was to the collective. The right to clean water was seen as an enforceable public right, and protecting it was an institutional duty.
That institutional strength is really the key here. It wasn't just a good idea, it was the law. What about things like land use or air quality?
Absolutely. The second major area was land use, sanitation, and nuisance control. Hisbah required the strict regulation of public roads and communal lands. This meant preventing people from, say, building out into a public road, which could affect drainage and maintenance.
So city planning, basically.
A form of it, yes. And more directly, the mutasib was responsible for waste management. They would dictate where waste could be disposed of to keep neighborhoods from becoming fouled. And they also regulated where you could put polluting businesses.
Like slaughterhouses or forges.
Exactly. Slaughterhouses, ovens, ceramic kilns, smelting operations. They had to be located far enough away from residential areas to minimize the smoke, the bad smells, and to keep the air quality acceptable.
It sounds incredibly comprehensive. They weren't just reacting to pollution, they were proactively designing the community to mitigate it.
That's it. It shows that the state, or at least the municipal authority, had a clear legal obligation to manage common property for the public good. And the core idea that Hisbah gives to modern law is this concept of public accountability and stewardship. In Islamic jurisprudence, these resources, the water, the land, are seen as a trust, an amanah.
A trust.
Yes, a trust held by humanity for the benefit of the whole community and for future generations. So if you pollute or degrade that resource, you're not just damaging property, you're breaching a sacred trust, you're harming the entire community.
When you put it like that, the connection to modern ideas like environmental impact assessments or even city zoning laws is striking. The philosophy is almost identical.
The continuity is profound. Hisbah established that taking care of the environment isn't a policy choice. It's a non-negotiable legal and public duty. Today, we codify that with constitutional rights. Back then, they codified it through a specific office and a moral mandate backed by legal force.
Okay, so let's fast forward 1,000 years. Why is this ancient concept so important for a lawyer arguing a case in a modern courtroom today?
Because when modern courts, especially in places with a common law tradition like India, Pakistan, or parts of Africa, are expanding the right to life to include the environment, they need a foundation. They need to show they aren't just creating a brand new right out of thin air.
They're not just being activist judges.
Exactly. By pointing to a concept like Hisbah, they can ground this very modern interpretation in an ancient universal legal principle that human flourishing requires environmental stewardship, and the law has always been the tool to enforce that duty of care. It connects the moral duty of the past to the constitutional duty of the present. It validates the court's actions.
That's a powerful intellectual bridge.
So-
Okay, so we've established the ancient foundation of duty. Now let's leap forward to the modern global legal framework that allowed this duty to be written into the highest law of the land, environmental constitutionalism.
Right. And if Hisbah was the seed of this idea, then environmental constitutionalism is the fertile soil where these environmental rights have really been able to grow and flourish in the last few decades.
So define that for us. What is environmental constitutionalism?
Simply put, it's the worldwide trend of taking environmental rights and duties and putting them directly into a nation's constitution. It's fundamental governing document.
Why is that such a game changer? I mean, why isn't it enough to just have regulatory laws? We have things like the Clean Air Act, the Clean Water Act, national forest policies. Why go through the massive effort of amending a constitution?
That's a really important question, and it gets to the heart of the legal hierarchy. The difference is all about vulnerability. Regulatory laws, like the Clean Air Act, are passed by legislatures,
Right, by politicians.
and they can be weakened. They can be repealed, they can be ignored if the political winds change, or if there's enough economic pressure from lobbyists. Their enforcement often depends on the budget of a particular agency. They're fragile.
Okay, I see.
But a constitutional right sits at the very top of the legal food chain. It's the supreme law of the land. When you put an environmental guarantee in the Constitution, you are elevating it to the status of a fundamental human right. You're putting it on the same level as free speech or the right to a fair trial.
That's the aha moment, isn't it? To use your skyscraper analogy again, the regulations are like the interior walls or the furniture. You can move them around. But a constitutional right is the steel frame, the foundation. You can't just change it without tearing the whole building down.
Precisely. And this has huge practical implications. First, it insulates environmental protection from the whims of day-to-day politics. And second, and this is the most powerful part, it gives citizens standing to sue.
Standing to sue the government itself.
The government, private corporations, anyone. And you're not just suing because they broke some minor regulation. You are suing because their actions are violating your constitutional right to a healthy environment. It completely changes the power dynamic.
So this is a global movement. How does it actually show up in different constitutions? Is it always the same?
No, it's actually remarkably flexible, and it tends to show up in one of three main ways. The first, and most direct, is an explicit right to a healthy environment.
Just stated plainly.
Yes. The Constitution will say something like, every citizen has the right to live in an ecologically balanced and healthy environment. You see this a lot in South American constitutions, like in Ecuador.
That's the one that famously gave rights to nature itself,
Yeah.
right, to Pachamama.
That's the one, a truly radical and beautiful legal interpretation. So that's the first type. The second major feature you see is a mandate of state duty.
What's the difference?
It's a subtle but important one. Even if the Constitution doesn't give an explicit right to the citizen, it will place a positive duty on the state. It will say the government must conserve natural resources, it must prevent pollution, it must act sustainably for future generations.
So it turns conservation from a political choice into a government's legally binding mission.
A mission that the courts can enforce. The Constitution of South Africa has a great example of this. And the third feature is enshrining key environmental principles into the text itself.
What kind of principles?
Things like the precautionary principle.
Which is basically better safe than sorry.
Essentially, yes. If an action might cause severe harm, you don't need absolute scientific certainty to stop it. Or the polluter pays principle. These act as instructions for the judiciary, telling them how to interpret all environmental disputes. It tilts the scales toward protection.
And this whole movement just exploded in the late 20th century. Why then? What was the trigger?
It was a direct response to reality. Many nations, especially in the global south, like India, Brazil, South Africa, were facing absolutely catastrophic industrial pollution. Their local regulations were just completely overwhelmed. And you have to remember, environmental problems don't respect borders. A polluted river doesn't stop at the state line. So legal scholars and activists realized they had to use the highest legal leverage they had. The Constitution was the tool to force government action and to protect marginalized communities who always bear the worst burden of toxic pollution.
Okay, let's unpack this a bit more. If a country adopts this, how does it really change the battlefield for an activist trying to fight, say, a new power plant in their town?
It changes the scope of what a judge can do. Under the old regulatory system, a judge's role is very narrow. They just check for procedural compliance.
Did the company file the right paperwork? Is the permit signed?
Exactly. Did the smokestack emissions go slightly over the limit on a Tuesday? The court is just a referee checking the rule book.
Okay.
But under environmental constitutionalism, the judge's scope explodes. They can now look at the actual effect of the power plant, even if it has a perfectly legal permit.
The question changes from, did you follow the rules, to a much bigger question.
Which
Is this activity, even if technically legal, causing so much harm that it violates the citizen's fundamental constitutional right to exist in a healthy way? So the court can intervene based on the real-world outcome, not just the process. That is a massive shift in power.
a huge shift. It basically says that a healthy environment is a precondition for all other rights. And it gives courts the authority to enforce that principle, even against the wishes of the legislature or the executive branch.
But that sounds like it could lead to accusations of judicial overreach. You're giving judges the power to define what a healthy environment is, which is a complex scientific and social question.
That is the central challenge, and it's where judicial wisdom is so critical. But the courts often respond by saying they're not creating new policy, they're upholding the foundational contract of the state. If the Constitution guarantees a right to life, it implicitly guarantees the right to the conditions necessary for that life.
A life with clean air and clean water.
Precisely. So if the legislature passes a law that allows a company to poison the water supply, the courts would argue they have a constitutional duty to strike that law down. They are the ultimate backstop for fundamental rights.
And that idea of the court as a backstop brings us perfectly from this abstract global movement to a very specific, very powerful case where this happened. Our sources highlight the precedent from Pakistan, the Shehla Zia case.
Yes. The Shehla Zia case, which was decided by the Supreme Court of Pakistan back in the early 1990s, is just a pivotal moment. It's cited all over the world, especially in common law countries, as a textbook example of how a court can be creative and innovative when faced with a new threat.
So set the stage for us. What was the conflict at the heart of this case?
The case was a petition filed against the state-owned power authority, the WAPDA. They were building a massive electrical grid station right in the middle of a dense residential neighborhood in Islamabad.
Okay.
And the petitioners, led by a woman named Shehla Zia, were terrified about the potential health effects of the high-voltage electromagnetic radiation from the power lines.
So this wasn't about the usual kind of pollution like smoke or sewage. This was something new, invisible, technical.
Exactly. And that's why the court's decision was so groundbreaking. The Pakistani Constitution at the time had a guarantee for the right to life and liberty. That's in Article 9. But it had no separate environmental clause. It said nothing about radiation or public health protection.
So the court had a big problem. How do you use a mid-century legal guarantee, Article 9, to protect people from a 21st century threat?
That was the challenge. And the way they bridged that gap was just profound. The court's reasoning was that the right to life, in Article 9, can't be interpreted in a narrow, restrictive way. It can't just mean the biological fact of having a heartbeat and breathing.
That's just animal survival.
Precisely. The court argued that life, as guaranteed by the Constitution, must mean a life of dignity, a life of quality, a healthy life. And you simply cannot have a life of dignity and quality without a healthy environment, without clean air, clean water, and freedom from toxic hazards, like high-voltage power lines.
So they essentially said that a healthy environment is a prerequisite for life. They asked, what good is your right to life if the conditions you're forced to live in are slowly killing you?
That question is the heart of the Shehla Zia precedent. And the court didn't stop there. They also invoked the precautionary principle. They said that even if there's scientific uncertainty about the exact long-term effects of this radiation, the court has to err on the side of caution to protect fundamental rights.
So what did they do? What was the final ruling?
They ordered the Power Authority, APPDA, to halt construction and to conduct a full, independent environmental impact assessment before they could proceed. They stopped a massive state project in its tracks, all based on a potential violation of the citizens' right to a healthy life.
So this case became the prime example of how judges, even without an explicit environmental clause in their constitution, could use their interpretive power to pull environmental protection up to the level of a fundamental right.
Yes. It showed the courts leading where the legislature was lagging. It was an act of incredible judicial innovation, and it created the legal logic, the phraseology that we're here to discuss. It paved the way for the core principle of this entire deep dive.
The ratio.
The ratio. The thing that fundamentally shifted the legal understanding of human existence in that part of the world.
Which brings us right to the climax of our journey. The definitive judicial statement that links everything we've talked about.
Yes. And what's so fascinating here is the sheer power of the legal principle that came out of cases like Shehla Zia. The idea that the right to life includes a healthy environment isn't just a nice sentiment. It's the decisive, binding legal reason, the ratio decidendi, that is driving modern environmental justice.
Okay, let's pause on that term for a second. For our listeners who might not be familiar with legal jargon, can you explain the difference between the ratio decidendi and, say, obiter dicta?
That's a crucial distinction. Obiter dicta means things said, by the way. It might be a judge musing about the beauty of nature or a moral duty. It's interesting, but it's not legally binding on future
It's
courts.
commentary.
Exactly. But the ratio Decidendi is the core legal reasoning necessary for the decision. It's the principle that solves the dispute. In Shehla Zia, the ratio is this. Because environmental quality is a necessary precondition for enjoying the constitutional right to life, any state action that threatens that quality is, by definition, a violation of that fundamental right. That ratio is now the binding precedent.
To really get the impact, we need to break down how courts are now interpreting the word life. We know it's not just biological.
Right, the legal interpretation moves way beyond the bare minimum for survival. It expands to include all the conditions necessary for a dignified, healthy, and meaningful existence.
So what does that include, practically speaking?
It means the right to life now explicitly includes things like 1. Freedom from toxic exposure, protection from carcinogens, heavy metals, radiation. 2. Access to essential resources, a guarantee of clean air to breathe and safe water to drink. And 3. Protection from nuisance. And this is expanding to things like extreme noise pollution, things that prevent the peaceful enjoyment of your home and community.
It's the difference between merely existing and actually living. So what does this mean for a polluting industry or for the government?
It means environmental harm is now on the same level as an attack on a fundamental human right. It's not just a regulatory infraction anymore. And that completely flips the burden of responsibility.
Explain that, the old model versus the new model.
Okay. In the old model, under just regulatory law, if a company wanted to build a polluting factory, all they had to do was prove they met the technical standards and the regulation standards that were often written with heavy input from industry lobbyists.
And the burden was on the community to prove they were being harmed.
Overwhelmingly, you had to prove that the pollution exceeded a specific numerical limit in the law. It's incredibly difficult to do, especially when a company has a valid permit in its hand.
Okay, so that's the old way. What's the new model?
The new model, driven by this constitutional ratio, flips the dynamic. Now, the government and the industry have to prove that their proposed factory will not infringe upon the population's ability to live a healthy, dignified life.
So they have to prove a negative. They have to prove their actions are safe.
They have to prove that they meet the high standard of the Constitution, not just the low bar of a regulation. It embeds the precautionary principle directly into constitutional law. And this is a powerful check against regulatory capture, where industry controls the regulator, and against legislative negligence, where politicians just fail to act.
So if a government agency issues a permit for, say, a huge toxic landfill next to a school,
The citizens can now bypass that agency. They can go straight to the highest court and argue that the permit itself is unconstitutional because it violates their fundamental right to life. And the court's first duty is to protect that constitutional right, not the agency's paperwork.
this is the moment to really connect all the dots for everyone listening. Let's draw a clear line from our four sources directly to this powerful ratio.
Absolutely. The progression is so logical. First, you have the ancient concept of Hisbah. It established the foundational moral and legal duty of stewardship. It proves that environmental protection has always been an inherent public duty, not some new policy idea.
It provides the historical validation.
Precisely. Second, you have environmental constitutionalism. That provided the modern global structural framework. It's the legal text that gave courts the power to act, elevating the environment to a supreme legal concern.
The steel frame for our skyscraper.
Exactly. Third, you have the Shehla Zia case. This is the practical application. It proved that courts could creatively interpret an existing right, the right to life, to tackle a new environmental crisis, even when the Constitution didn't explicitly mention the environment.
It was the judicial proof of concept.
It was. And finally, all three of those elements converge into the core ratio. Right to life includes a healthy environment. This is the ultimate legal leverage. It transforms what used to be a minor policy dispute into a fundamental, actionable human rights violation.
And that is the legal tool you, the listener, need to know about, because it means these issues are no longer just policy debates that can be won or lost on lobbying money. They are now issues of constitutional rights enforceable in the highest courts with a permanence that mere statutes can never have.
That's the power of this evolution in legal thinking.
So the journey we've taken today, from ancient religious mandates about protecting water and land, all the way to this modern recognition of environmental health as being integral to the right to life, it shows a really clear and powerful trend.
It's a story about how the law is scrambling to evolve and catch up with the existential realities of our century.
And it really underscores the power of the judiciary, doesn't it? When the political branches, the legislatures, the executives are too slow or too captured by special interests to act.
The courts, armed with precedents like Shehla Zia and the principles of environmental constitutionalism, have the mandate to step in and drive progress. They're acting as the ultimate backstop against ecological collapse by framing it as a constitutional crisis.
We've seen that the law has moved beyond just punishing one specific polluter. It's now capable of viewing systemic environmental degradation as a violation of the most fundamental promise a state makes to its citizens, the guarantee of life itself.
And, this leads us to our final and I think provocative thought for today, that legal precedent is now crystal clear. A dignified life requires a healthy environment.
Right.
So this raises a huge question, especially when we think about the biggest environmental crisis of all, climate change. If a government, whether through just chronic inaction or by actively subsidizing fossil fuels, fails to act on climate change and allows conditions to get so bad that they threaten the health, the food security, the physical safety of its citizens through floods, fires, extreme heat.
And things we are seeing happen right now.
Exactly. Does that governmental failure itself become a clear and actionable violation of the constitutional right-to-life ratio that these landmark cases have established?
That is a profound implication, because if courts start to accept that argument, and we are seeing climate cases based on this logic being filed all over the world,
Then climate change litigation is no longer about nuisance lawsuits or challenging a specific regulation. It becomes a fundamental constitutional battle over the state's duty to protect its citizens' very lives.
it suggests the courtroom might not just be one path for environmental action. It might be the most crucial, high-leverage battleground for the future of environmental protection and human rights.
Something for all of you to think about as you consider the laws governing your own environment and the tools you have to enforce your constitutional right to a healthy life. Thank you for joining us for this deep dive.